Good morning, everyone, and welcome to our second day of our Leadership Summit for Special Education Leaders, Leading Effective Practices to Support Equitable Outcomes. My name is Paula Schmidt, and I'm the director at Patton Pittsburgh, and I'm thrilled that you're joining us today. Just a couple logistical announcements. I want to remind everybody that this session is being recorded and closed captioning is available. So you can, to access closed captioning, just click on the icon in the Zoom control panel. I also wanted to let you know that handouts for this session and all sessions can be accessed through the web page. So I just put in the chat the access to the handouts, so you can click on that if you need that. And I wanted to let everybody know that our esteemed presenter this morning, Trish Andrews, has a really rich and robust PowerPoint to get through cases with us. We will take questions if you want to include those, but we don't want to get too sidetracked with going too in depth, because she really wants to get through as many of the cases as she can. So if you have a pertinent questions, please feel free to add that in the chat, and if we can get to it, we certainly will. So I am going to introduce our presenter this morning. Mrs. Andrews is a partner with the law firm of Andrews & Price in Pittsburgh, Pennsylvania, working primarily in the school law section. She represents the firm's school clients and acts as special counsel to a number of school districts in special education matters. She coordinates the firm's publication of the Special Education Alert newsletter published through the Tri-State School Study Council at the University of Pittsburgh. Ms. Andrews is a member of the Allegheny County Bar Association School Solicitors Section and was the 2011 president of the Pennsylvania School Boards Association Solicitors Section. She received her Bachelor of Arts from the University of Pittsburgh and her JD from the George Washington University National Law Center. So without further ado, I'm absolutely thrilled this morning to introduce our presenter, Trish Andrews, who's going to talk about due process during the pandemic. So Trish, take it away.
Okay, thank you, Paula. I was telling Paula before we started, I guess technology is a good thing. I'm actually presenting to you from Pigeon Forge, Tennessee, where my son's playing in a baseball tournament, but even I, and I'm sure everybody there can agree that I think we would all rather be at Bedford Springs right now than even here in Tennessee. So excuse my casualness. I could not bring myself to bring a suit to Tennessee on vacation. So, all right, without further ado, because I do have a lot of information, let's start going through some of the cases. Before we start, let me just tell you a few things that, you know, when we were discussing doing this topic, due process during the pandemic, the topic itself, you know, we were thinking there might be a lot of due process cases that have come out on some of the pandemic issues. Then I did see that the hearing officers are doing a very similar presentation next. So what I've sort of changed this to is what are the cases that we have seen coming out in the last year during the pandemic. During 2020, obviously, most of our federal courts were shut down. They were doing some work, but we weren't getting a lot of decisions coming out. But in the last 6 months, there have been a lot. So I thought that this was a good topic for us to talk about, to look at what are we seeing from the courts as we're coming out of, hopefully coming out of the pandemic. So I want to talk about some of the trends that we're seeing in the event that you do get into a due process case, and what we can hope that will have the hearing officers following some of these cases. So I picked, there were a lot of cases, like I said, I picked some so that we can see some trends. We can look at different areas. You know, I will also say that I know that when we're going through some of these cases, if you're on and you're the special education director at the school, I know you know these cases backward, forward. You've been dealing with them for years. You've been dealing with the families for years. You know much more of the facts than I am ever able to see based on, you know, a 6, 7, 10 page federal court decision. So, you know, I've been there, you know, I've been in seminars where someone's been talking about my case and they summarize it and I think, oh, but what about this and this happened, and you know, so just bear with me when we're going through it if this is one of your cases. And as Paula said, if it is and you have something you want to add, feel free to do that as we're moving forward. But I think that again, I want to look at some trends that we're seeing that the courts are following. Now, one of the other things that's important to understand when we're going through federal court decisions is that the majority of federal courts and the majority of special education decisions that we have uphold the hearing officer's decisions, okay? And that's important for you to know and important for you to understand. If you are in a due process case where, you know, you may not necessarily like or agree with the outcome from the hearing officer, it's something to think about before you say, oh, we need to appeal this, we need to get to federal court, because most of the cases uphold the hearing officer's decision. The reason for that is that we have this standard of review for special education IDEA cases that's called a modified de novo standard, meaning that the courts don't just look at the cases from scratch. They don't just ignore what happened in the due process arena and make their own decision. They get the entire educational record, the entire due process record from the Office for Dispute Resolution. They have the transcripts, and that's a good thing because in most cases then people don't need to come back in and retestify. But they do give deference to the hearing officer's decision. So that's important to know as we go through some of these cases, looking at how we got to where we got to. I will also tell you, you know, and I'll point these out, when we're looking at some cases, you also need to know bad facts make bad law. If you have facts that are not on your side, it's something you really have to think about when you're going into due process and then appealing that decision to federal court. Okay, so let's just jump right in. Okay, the first topic that I want to talk about is the topic of FAPE, free appropriate public education. As you know, we are seeing more and more cases come out of the federal court that are really giving school districts good decisions based on the Andrew F. case. So in this case, Maggie J. versus the Donegal School District came out of the Eastern District of Pennsylvania, and the court held that Maggie was offered an educational program reasonably calculated to enable her to make progress that was appropriate in light of the circumstances, in accordance with the Andrew F. case that came out a couple of years ago from the United States Supreme Court. So we're seeing a lot more cases that are highlighting appropriate, that are highlighting reasonableness, rather than this focus on, well, how much progress did the student make? Their courts are really focusing on looking at the IEPs to make sure they were reasonable in light of the student's circumstances. Okay, so this is a case that, you know, even if you are not the special education director at the Donegal School District, you've all had, sorry about that, you've all had, you know, the family that no matter what the school thinks the student needs, the parent feels that they need 10 times more than anything that you have offered. So Maggie and her 3 biological siblings were adopted. They were removed from their biological mother for neglect. And Maggie's mother immediately began to advocate for her to receive additional instruction and services through early intervention, and then as she moved into kindergarten. Maggie was one of these students that, you know, didn't have a bright line diagnosis or a bright line issue. She had a borderline IQ of 78. Because of that IQ, that lower IQ, the district was not seeing discrepancies with her achievements, so there was no learning disability. She was fidgety, distracted, not significant emotional issues, and the teachers all said, look, you know, we're able to redirect her. She's typical kindergarten student. All of our kindergarten kids are fidgety and distracted, but she did qualify for speech and language services, and the mother agreed with the evaluation. So the following year, again, you all have seen these families, qualifies for speech and language. Parents come in with an outside evaluation. She was originally evaluated for ADHD, but the psychologist said, no, she has reactive attachment disorder. She has oppositional defiant disorder. So the mother then said, oh, look, she has these emotional issues. I want her placed in the emotional support classroom for first grade. The teacher said, really does not need that level of support. We're able to address her needs in the regular education classroom. But, again, she goes into first grade. Her behaviors do start to increase. But the school district starts providing her with programming from the guidance counselor, although these services were not included in the IEP. One of the mistakes that did not lead to any finding from the school district because it was a procedural error, but something that I think is really important to highlight in this case is that the school, and again, if you're the special ed director, I apologize, these are the facts from the case. The district continued to take the position that Maggie had a speech-only IEP. And because of this speech-only IEP, could not or should not put additional services into the actual IEP. Please remember, because hearing officers will get you on this, I lost this case 20 some years ago, that once a child qualifies for special education services, even if it is only speech and language, that is a category of eligibility. Once they qualify, then all of their needs should be addressed in the IEP. So even if it is the student only qualifies for speech and language services, all of their needs, whether that's reading needs, emotional needs, math needs, all of those needs then can and should be identified and programmed for in the IEP, even if the child does not have a learning disability or an emotional disability. We need to make sure that all of the students' needs qualify. And the court did highlight, look, there really is no such thing as a speech and language only IEP. Once they qualify, they qualify. Okay, so at the end of that year, the district again said, no, we're proposing a speech only IEP. They did not offer ESY, did not offer a formal positive behavior support plan. Like I said, they were doing some additional services, but they did start a reevaluation to look at whether or not there were other eligibility categories. The parents disagreed, began talking about, look, she is emotionally disturbed. We need to revise her IEP. She should qualify for summer services. And, as far as wanting her retained in first grade. Now, at this point, based on the new information in the reevaluation report, Maggie does now qualify as emotionally disturbed. But immediately after the district puts together their IEP, Maggie's hospitalized. When she gets out, she comes back to first grade. Her report card's a little bit worse, but and important based on the Andrew F. case, she was still meeting expectations academically. Second grade, again, the IEP addresses her emotional and behavioral needs now. Again, the school district said, oh, now she's emotionally disturbed, we can do that. Mom wanted Maggie in an emotional support classroom. The school district said, look, we haven't even tried a formal functional behavioral assessment. We need to keep her in the least restrictive environment. And based on the positive behavior support plan, her behavior started to improve. So second grade, again, the progress monitoring showing progress. Even though she wasn't mastering her skills, she met expectations in most areas. And that included in her behavior plan. Parents sought an independent evaluation, new IEP for third grade. Now parents say, we're bringing in a lawyer. They disagreed with the IEP and said that it did not contain enough supports for her, did not include every recommendation that was in the IEE. Remember, our obligation for an IEE is to consider the independent evaluation, we don't necessarily have to accept the independent evaluation. And that's obviously something that's difficult for parents to understand, but we don't have to agree with everything that's in an independent evaluation. So now we get to third grade. Maggie's behaviors do start to increase. The district provides additional support, including more time in an emotional support classroom. They were tracking her behaviors, honestly, to the point where the special education teacher was, minute by minute, almost emailing Maggie's mother about every behavior that occurred, which, is a good thing. It's good to have communication with the family, but when that starts happening, it is difficult in due process because it makes it look like these behaviors are so significant because there is, an email stack that's like this thick with emails between the parent and the special education teacher talking about behaviors that have occurred. But her report card still showed progress and that she was meeting expectation. Okay, so when we're looking at FAPE and what we know from the Andrew F. case, and this is how the court analyzed this decision. The IEP, as we said, has to be reasonably calculated to enable the student to make progress that's appropriate in light of their circumstances. So, what an IEP is going to look like for a child who is significantly emotionally disturbed may look different than a child who is going to look different than a child who has a minor learning disability. So we do have to make sure that that progress is calculated to be more than de minimis, more than just a small amount of progress, meaningless progress. But the student, one of the things that was highlighted in the Andrew F. case, especially for kids that are in regular education classes, is that the student should be able to progress through their grade. They should be able to move from grade to grade. Okay, so the hearing officer found no denial of FAPE, essentially found that the school district addressed her needs as they came about, as they saw them. First grade, she was evaluated when it was clear that she needed some type of service. Second grade, it was revised to include appropriate goals, services, and a positive behavior support plan. As I said, this teacher was not just providing daily communication, was providing almost minute by minute communication that showed that she was improving in her behaviors. Even if she had a significant behavior here or a significant behavior there, the record as a whole showed improvement. Third grade, there were, as I said, these two major behavior incidents, but the rest of the year was pretty good. School district was able to distract her. So the hearing officer said, no, just because she had a couple of behavior incidents doesn't mean FAPE wasn't provided. And the district implemented consistent behavior supports during the school year. And as I said, when we're looking at what the hearing officers said, the court in this case agreed. It was upheld the hearing officer's decision, which, as we said at the beginning, not unusual. That's what we are generally seeing with our courts, not a lot of overturning of hearing officer cases. Okay, another case, Esposito versus Ridgefield Park School District. This one now goes to the Third Circuit Court of Appeals. The issue again is FAPE, where again, affirming a decision that an IEP was reasonably calculated to enable the child to make progress. Okay, so this one again, when I'm going to highlight some of the issues that even though the school district won, I want to caution you as special education directors on the advice that I give my clients, but I know everybody has their own solicitor and does their own thing, but in this case, KM began receiving special education services in 2005 when he was in second grade with a language disorder. Okay, then the next 6 years, the evaluations were waived. Okay, so the school district did not get any new evaluation data on the student in 2008 or 2012. Then by this time now, the student is a senior. So the first evaluation is in second grade. The second evaluation is in 12th grade, 10 years later. So I can't stress enough that I do not recommend, I don't like waiving evaluation reports at all. Sometimes I understand if they're in their senior year, we don't want to put in, everything's going fine, we don't need anything. But waiving evaluations for 10 years can lead to significant problems. In this case, this was just like, let's do an evaluation so we can help decide some post-graduation transition planning. And unexpectedly, the district sees significant drops in intellectual abilities. Okay, so that's difficult because they don't have an evaluation to compare it with since he was in second grade in 2005. If you have those triennial evaluations, you can, they would likely be able to see, hey, this is something strange that happened. We saw it in 2008, it was the same. In 2012, it was the same. Or they may have known that he had a traumatic brain injury or something that happened along the way. But with no data, that's really hard to defend moving forward. Again, school district wins. So I don't want to, I'm not trying to put down the school district or say they had any issues, but just, highlighting a few things that I see in some of these cases along the way. So parents then 2 years after that file for due process. They're seeking remedies for that 10-year period. Luckily, court did say, agreed with the hearing officer on the statute of limitations, set a statute of limitations starting in 2015 when the school district did their reevaluation. And he said at that point was the time of the new or should have known date. But in this case, one of the things that's important is that the parents' witnesses were found to be unpersuasive. And the courts, if the hearing officers find decisions of credibility for hearing officers, the courts have to accept those credibility decisions. So in this case, the hearing officer said, look, in contrast to what Andrew F. said, these experts that the parents were bringing in, all they were doing was Monday morning quarterbacking and second guessing decisions after the fact. They weren't looking at what did the school district know at the time, what was, what was the situation as the family and the school district moved forward. They were just looking at it in 2017 saying, hey, the district was wrong. They should have done something different. So the hearing officer said, no. Andrew F. specifically said, we don't Monday morning quarterback decisions. We base the decisions on what did the school district know at the time they were making the decisions. So, so once the hearing officers found the school district's witnesses to be more persuasive, more credible than the parents' witnesses, the court has to accept those credibility determinations. And they did agree that the program was appropriate. And that's our standard, remember, free appropriate public education. Student attended general education courses, except had a special education class in language arts. And the court held that it was reasonably calculated to allow him to achieve passing grades and advance from grade to grade. And that is straight out of the Andrew F. decision. But I will say those waivers of the 10 years of evaluations did leave the school district vulnerable to litigation, which even if you win, if you've been involved in litigation, it is costly, it's time confusing, it's not necessarily fun. It does take up a lot or most of your time. So, even if you win, it is a significant time consuming experience. Okay. Another Third Circuit decision, and this one I thought was interesting. It was a child find / pendency issue where the court held, look, just because the parent told the school district of the student's history of trauma did not put the school district on notice that they had to begin an evaluation for the student. In this one, interestingly, this was an initial provision of special education services. The parents didn't agree with what was being offered, and the court all the way to the Third Circuit held, no, the student stays in their educational programming while the parent filed this lawsuit for pendency. And again, if you've been involved in any of these cases, you know that, for example, that case that we talked about, the last case, Esposito, they filed for due process in 2017, and just the district court decision was coming out in 2021. Now we're at the Third Circuit, or that was a Third Circuit decision. So going up to the Third Circuit can take years, where a student may or may not receive the instruction while the parent is fighting it, but that was their decision to do. Okay, so while the student was in middle school, entered into the school district, parents started talking to the school district about their daughter's emotional difficulties, some history with trauma, difficulty adjusting to new surroundings. That mother told the school district that the student was in therapy due to child trauma, told the counselors that she was engaging in self-harm. But it wasn't until the spring where she started having some issues in math. So the mom asked for a formal evaluation. She did not qualify for anything at that time. The school was not seeing any issues in the school setting. But they did put in some, regular education supports for her that were available. But after the evaluation, now LS starts to really decline. She becomes very depressed. She's not going to class. She's ignoring her friends. The school social worker said, hey, you may want to take her to a hospital. She was hospitalized for 4 or 5 days. When she comes back to school, the school immediately had a transition in place for her to start meeting with her counselors. They changed her school schedule so she could still go to outpatient therapy. And at this time, then the school said, look, we better redo this evaluation because we weren't seeing these emotional issues when we did the first evaluation. Let's do another one. Now we're seeing some significant issues. Her emotional issues are severe enough at this point that she qualifies. So they have an IEP in place by the very next year. So students in school for 1 year, next year already IEP being offered. But before school even starts, parents filed for due process. They said, the school district violated child find. They should have identified her emotional problems in that first evaluation, or even earlier when mom started telling them about the emotional issues that she was having at school. And she challenged the IEP, said the IEP doesn't provide enough emotional support for her and doesn't meet her needs. So the school said, well, look, if you don't agree with what we're providing to her, then she goes into regular education unless you agree for us to start providing services to her. So again, I do not know the facts of this case. Sometimes you can talk to the parents if they are reasonable about, look, even though you disagree, you think there needs to be more, at least let us get in place what we have. You can write the NORAP that specifically says parents don't agree with the actual program, but they agree to start the initial provision of services so that you can get something in place for the student. Again, that only works if parents are reasonable. I don't know the facts. They didn't talk about that in this case. So I don't know whether or not the school district offered that to the family, but it's something to think about if you're in, a situation like this where, you can't even start services because the parents are in disagreement. Okay. The hearing officer said the program was appropriate, but disagreed with the school district on the pendency issue. They said the school district should have started services and awarded compensatory education for math for the period of time that she missed. The district court agreed that the school district timely evaluated her, but they reversed on the issue of compensatory education based on stay put. So no child find violation, promptly identified the student. The schools have to promptly identify all students who need special education services. And once the school is on notice that the child may be developed, they have to evaluate within a reasonable period of time. But the Third Circuit looked at other cases that said that doesn't mean that the first time a child has any issue in school, that school districts have to immediately begin evaluating the child. We only have to do what is reasonable based on what we know at the time. Schools don't have to rush to judgment, do immediate evaluations. Every time a parent comes in and says, oh, my child had an issue, but you do have to be careful. You can't let, especially, those middle school, high school years, and I talk to special education and regular education teachers about this all the time, that, I think a lot of times middle school teachers, high school teachers don't necessarily refer kids as much as we see in the elementary. They kind of have this mindset or this belief that, well, if this kid had a disability or they needed something, it would have been identified long ago. So, where schools get into trouble, not in this case where within a year the student was evaluated, but where the student continues to have emotional issues and the school fails to evaluate. So be careful of those things. But this case said, no, you know what? You don't have to rush to judgment just because a parent reports something. There was no notice of a disability in this case. Her grades were fine, no behavioral issues, no evidence of any emotional problems that were impeding her learning. But once she did start to have those significant issues, the school district jumped in and did an evaluation and identified her. The court did say, though, that stay put. Once a parent sues the district, the statute said the school shall leave the student in their current educational placement until the lawsuit is over. Now, again, as I said, parents in the school can agree on another placement, but if you don't or you cannot, then the student's placement stays status quo. In this case, it was regular education. All right, another child find case out of the Eastern District. The school district conducted, sorry, let me just move this because I'm appropriate evaluations, finding the student ineligible. Okay, so again, the court in this case, I'm not going to go into this because it was very similar to the decision before, and we're limited on time. So, but the court essentially holds again in this case that not every child who has any issue at school requires a full-blown evaluation or is eligible for special education services. Every child has strengths and weaknesses. The teachers testified that in this case, Gwendolyn was almost at grade level. They did do tiered intervention for her, which we're again allowed to do. We are allowed to provide tiered services before we even look at special education services. However, remember, we cannot say no to an evaluation just because a student is receiving tiered services. If a parent asks for an evaluation, you either have to go to due process and defend your decision to say no or conduct the evaluation. And she was making progress. Okay, so, but now I want to contrast that with this Eastern District case where the court opines that multiple requests from a parent was sufficient to thoroughly evaluate a student. So, as you all know, every case is fact specific. Every case depends on what hearing officer you get, what the facts are, how much time there was. There may be, something small in there that leads a hearing officer to a different decision. But in this case, the mother had been discussing with the students, discussing with the school, the students' academic and behavior issues since kindergarten. The parent was saying, look, I can't get her to school because the meltdowns at home are so significant that I can't even get her out the door in the morning. She was having issues completing her homework. The parent continued to say, can I get accommodations? And the school district did not do a full or thorough evaluation. And as a result, reasonable accommodations weren't provided to the students. So, keep in mind that, again, fact specific, those original cases, students were doing well within the educational setting. There weren't problems. The grades were fine. We weren't seeing behavior problems. But even if the behavior problems are at home, if they are affecting the student's progress, affecting their ability to even come to school, we should be looking at conducting evaluations. Okay. Now we're going to look at a tuition reimbursement case, Eastern District. And again, I just want to show you some trends that we're seeing, a lot of FAPE cases, child fine cases, and child fine cases, before we get into tuition reimbursement, almost every case that gets filed, parent attorneys throw in a child fine claim. And the reason for that is that it is very easy for them to argue, oh, a school district should have done something earlier. And for a hearing officer to say, well, yeah, okay, I'm going to pick this other date. Yeah, I think in hindsight, the school district should have done something a little bit earlier. So it's an issue that I think parent attorneys see some success with at the due process level. So we see a lot of cases when parents are talking about FAPE that they throw in a child fine claim as well. All right, so tuition reimbursement, and the school district was required to provide 1 year of tuition reimbursement for this student. So MD attended Colonial School District for 3 years, was identified as a student that qualified for special education services, but the parents were not happy with those services. They weren't happy with the amount of progress that MD was making within Colonial, so they withdrew her and enrolled her in a private school for a 2-year period. Now, this is one of those cases that I said bad facts make bad law, really. The timing of this, just like, and you all see it, and I think it's just something to be very aware of. And this is actually something different than, honestly, what I have always told my school districts as well. And I think different than what the state had been advising schools. I might be wrong about that, but what I had always advised. So parents come back in April in 2019 and they say, we're going to enroll MD, not now, not in April 2019, but we're going to enroll her to start the 2019-2020 school year, and requested an IEP. So they also provided the school district with updated medical records explaining new diagnosis. So the school district issued a permission to evaluate for an initial evaluation. They did have a gap in time here where parents come in April, school does not issue the permission to evaluate until May. So there was a month gap in time. Again, those little things are, can be detrimental from a hearing officer's perspective of when they find you should have done something differently. Okay, so the permission to evaluate issued in May comes back, signed. However, because of summer, the school district said, well, we don't have to do a new evaluation prior to the start of the school year because we have 60 days to complete it. Our time is due in September, and we don't even know if she still qualifies for special education services. So we'll do our evaluation, and when that's done, then we'll look at whether she qualifies and whether she needs an IEP. So, they didn't offer that IEP to start the school year. Parents had requested it multiple times. When are we going to meet? Where are we going to go? How are we going to start the school year with an IEP? And the school kept saying, look, it's summer. We don't even have our staff here. We haven't done the evaluation. So they complete the evaluation in September, complete the IEP in October. Okay, which was in timelines from the date the permission came back. All right. However, the parents said, no, we're not re-enrolling because you haven't offered our student anything. You have not offered our child a program. We're keeping her in the private school. We're giving you 10 days notice that we intend to place her in that private school, and we're going to seek tuition reimbursement. Remember, that 10-day notice is in effect so that the school can take action. They can say, okay, look, we have 10 days to try to correct any problem that we have. But the school was still taking the position, no, we have to complete the initial evaluation and then do an IEP. And again, I'm not faulting Colonial. It's exactly what I would have advised my schools to do. But the hearing officers and the court found against the school district. The court did overturn the full award of tuition reimbursement. By the time this got there, it was multiple years, but they said no, they get 1 year of tuition reimbursement. And the court found a procedural error saying that the student should not have been given an initial evaluation when they came in. It should have been a reevaluation. And had they done a reevaluation, they could have said, okay, the student qualifies, and had an IEP in place to start the next year. So, they could have done a reevaluation, reviewed records, reviewed the input from the outside evaluator, had an evaluation done. And the court also said, look, if they would have started it in April when the parents came in and said, we want to start the process, they could have had things in place even earlier. But importantly here, when kids are evaluated by the school district, they are eligible for special education services. They leave, and when they come back, the court has said that the students don't lose their IDEA eligibility simply because they left for a period of time. They said once a child is found eligible for special education, they remain eligible until an evaluation finds them to be ineligible, even if they leave the public school system. So, this is really important because I think it is very different than what most school districts do when kids move out of the district and go to a private school where they may not have been receiving any form of special education services during that period of time. And then again, the court said, look, when a parent asks for an evaluation, the law says that that permission has to be readily available to the family. Generally, we look at a 10-day period, but that's not written in stone. But the court said here a month delay wasn't appropriate. And again, had they done it immediately, the evaluation could have been in place. So I think, I wasn't there, this isn't written anywhere, but knowing, doing due process hearings for 20 some years, I do think that probably that month delay in issuing that evaluation probably led to, a snowball effect of some of the decisions that, that resulted from this case. But that's important to know. If a student moves out and they come back in, you can do a reevaluation. It's not an initial evaluation if they had previously qualified. They remain eligible until an evaluation says something different. Okay, so now we have a transportation case. This was an interesting case. Penn Hills School District, this came out of the Western District of Pennsylvania and dealt with private school transportation. And the issue in this case was the school district, or the courts looked at this strictly from an accommodation standpoint under 504 and said that the school district had a duty to transport the student, to accommodate the student's transportation needs under section 504. So this student is a resident of Penn Hills. He was enrolled in Pittsburgh Central Catholic High School. He had been diagnosed with asthma, depression, anxiety, and a peanut allergy. Penn Hills did provide the student with transportation to Central Catholic because of our regular Pennsylvania laws that just say that all schools have to transport every student who is enrolled, if they provide transportation, who is enrolled in a private school, if that private school is located within 10 miles of the school district's border, which Central Catholic is within 10 miles of Penn Hills border. So they were providing DA with transportation. Now, prior to 2019, 2020, he was receiving door-to-door transportation based on a 504 plan. But the school district then in the fall said, oh, you know what, we'll continue to provide you with transportation, but we're not doing door-to-door anymore. So the family filed a complaint with OCR. This was settled in mediation. Again, the cases don't give us a ton of facts here, but the following month, then the school district said, Well, since you're in a private school, we're not really sure why we were providing you with a 504 plan anyway. So we're going to get rid of that 504 plan, and we're just going to provide you with the same transportation that we provide to everybody else, which is not door to door. So now the family files for due process. The parents argue it under this equal access 504 accommodation. They had an obligation to accommodate him so he could access the transportation and failed to do so. The school district tried to say, look, we don't have any obligation to provide him with a FAPE or with specialized transportation under the IDEA because he's enrolled unilaterally by his parents in a private school. We don't have that obligation. The court agreed with the parents in the way they framed the case and said the issue was whether or not the student was denied equal access to busing services because the school district refused to accommodate the request for door-to-door transportation. The court looked at whether or not he was denied the opportunity to participate equally in a program of the school district rather than was he denied FAPE. Okay, and the court found in favor of the parents. Again, we know that the law requires us school districts to transport, and the court said once they are required to transport, they have to provide the same transportation to students that attend those private schools as they would if the student was enrolled in a regular education environment, enrolled in the school district. So Penn Hills is located within 10 miles. They were required to provide the transportation. And once they offer transportation, then they cannot discriminate against students because of their disability by denying them equal access to that transportation. Okay, so to accomplish equal access, the court said that the school has an affirmative duty to make reasonable accommodations to avoid discrimination. Have to provide access to the program, in this case transportation, that's equal to the access that's provided to non-disabled peers. And in this case, there was no factual dispute over whether or not the student needed door-to-door transportation. According to the case, each party agreed that DA did need door-to-door transportation to access that transportation to Central. So the court said, look, if he needs that, then that is a reasonable request from the family for him to access services. So, you know, I mean, if you think about this one is a little bit different, but just think about a student, for example, who is in a wheelchair. And we say, okay, well, we offer transportation. And if he was enrolled in Penn Hills, he would have gotten transportation on a van that was wheelchair accessible. If we are providing him with transportation to Central Catholic or any other private school that's within 10 miles, in order for him to even get on that bus, he's going to need a bus that is wheelchair accessible. So, you know, this case was a little bit odd because the facts were not really, through the court, developed to determine why he needed that door-to-door transportation, but everyone agreed that he did. So when you think about it more in terms of, you know, that wheelchair accessibility, the decision in this case makes sense. We have to make sure that just because we provide transportation, the student has to be able to use it. They have to be able to get on it. They have to be able to access it. If they can't do that because of their disability, then we are discriminating against them under Section 504. Okay? All right. Now this one is another Third Circuit decision, AB versus Abington School District. I probably should have moved this more into the child find, that again, parents' emails and conversations did not trigger the district's responsibility to conduct evaluations under the IDEA. The student receives special education services from 1st through 4th grade due to a diagnosis of autism. Then the parents unilaterally placed him in a private school. The school district informed the parents that they would offer him an appropriate program if he ever re-enrolled in the district. And more than a year later, the parents started asking like these really general questions. Well, what services would you have if we enrolled? conversations with the principal about possibly enrolling the student. Then a month later, again, special education director, well, what services could you offer? And then the parents said, well, you didn't offer us anything, so we're seeking tuition reimbursement. In this case, one of the things that the court found interesting, and again, facts are very specific, that separately, the parents did specifically ask for an evaluation for their other child who was also attending private school. So they did know how to specifically ask for an evaluation. In this case, they just kind of beat it around the bush and said, well, what could you do? What might we do? And so the court in this case said, look, you knew how to ask for an evaluation. You withdrew them 2 years ago. Your request is not enough for the school district to start an evaluation. You either have to specifically ask for an evaluation or begin that re-enrollment process in order to get an evaluation. Vague statements were not sufficient to start that evaluation process. Okay, I see Paul is on, so I know I only have a few more minutes, so I'm going to try to rush through some things.
9 minutes, 9 minutes, Trish.
9 minutes, okay. And I don't think we had any questions coming in so far. Is that right, Paula? Okay.
That's right. I haven't seen anything, so just keep going. We're good.
Okay, sounds good. So this one, again, another tuition reimbursement. The court upheld reimbursement for a unilateral residential transition program. I put this case in here because I know in the Western District, we're seeing a lot of these types of requests from parents. And, I assume that you all are across the state for students who are intellectually disabled that are, going into their 13th, 14th, 15th year, looking for more than what the school district can offer, looking for those like college type placements. So that's really what happened in this case. Student was intellectually disabled, 11th grade, received some transition services through the Montgomery County Intermediate Unit, where she did some career exploration transition programming. In 12th grade, she attended the high school, participated in more transition type services, also worked as an aide in the office. She was the manager of the soccer team. When she was in her 13th year, she did the Montgomery County's apartment program 5 days a week, where she did some independent living skills in a simulated apartment. Also practiced more of her pre-vocational communication, independent living skills in the classroom, was an office aide. Then the parents started looking at some of these outside programs and found this program called VIP, which is a residential transition program in New York for students with disabilities. At the end of the year, the parents informed the district that she wasn't ready to graduate, asked them to fund the placement at VIP. The school said, look, we agree she's not ready to graduate, but we can continue to provide her with transition services here in the district. They proposed an IEP that focused more on functional skills, identified transition needs, and offered either their high school or a VOTEC program. The school district or the parents toured the VOTEC and said, well, we like it, but it's only offering her one program, early childhood at the time. And they said, we're not even really sure that's still what she wants to do or what she likes. That's changing. And they said, now, yes, she did the apartment program, but she still has independent living skill needs that aren't addressed. Again, asked for this VIP program. The school said no, and so the parents unilaterally placed her there. While she was there, of course, she did well, and I'm going to skip through some of these things. Lived in the residence hall, met with counselors, social functioning, different things, did well. parents brought in experts to say this was a great program, she was doing well, and the school district's program was deficient. Again, the school for the next year then offered different transition services. Also said we can reevaluate, but again, in the summer, we're not going to do that. She returns to the VIP where she continues to do well, and then she ages out. Okay. Parents filed for due process. When we're looking at tuition reimbursement, we're looking at, was FAPE offered? And if not, was the unilateral placement appropriate? The hearing officer found that the school did not offer FAPE to the student. Transition services should be looked at the same as any other FAPE services. Was what the school district offered appropriate? Did it meet the student's needs? And it is important to know that the Third Circuit has yet to define what amount of transition services are appropriate to ensure FAPE. But in this case, the court said that they did not offer the student with FAPE because that VOTEC program only exposed the student to one vocation where her interests were continuously changing. So just putting her in one program, the court said, wasn't appropriate. So, you know, what is really important in transition services, and I will tell you, I've had several transition cases that have gone from one end of the spectrum to the other. We don't have really a very good standard of what hearing officers are looking at. I think for transition services, I did have a decision in the Western District where one of the hearing officers said no. The school district that offered and met the student's needs did not have to provide services at Duquesne University in a St. Anthony's program. But in this case, they said it was not appropriate because it did not meet all of her needs. So make sure those transitions programs and services, identifying needs, meeting all of the needs, and providing an appropriate program. Okay. So, you know, they did award tuition reimbursement, and the court in this case did emphasize that this was an individual decision for this student only. So ensure that what you're offering is individualized, it meets the student's needs and addresses all of those needs. Okay, so I think what 3 minutes left, Paula, you know, just really quickly, just threw in a gifted case also, gifted evaluation. This case was a parent who said that the school's evaluation for gifted discriminated against her child because that child had a disability. The school district did screening tools. Even though the screening was low, they still conducted the evaluation. The student's full scale IQ was a 123, GAI 125. The school district still said, look, we're not just going to look at the IQ, we're going to look at all of the evaluation criteria. Doing well, although he was doing well, they just did not meet any of the criteria for gifted eligibility. And the psychologist really was good, knew what she was doing. And the court said the student's IQ was under 130, but the school district did look at those multiple criteria and agreed that as a whole, the criteria did not need or meet the indicated need for gifted services. So the parents were unable to show that the student was eligible. All right, I got that all in 1 hour. So
Awesome.
I know we went really fast. I think I have my email address on the PowerPoint, you know, so if there are any questions, if anybody needs anything, you can always reach out to me individually or through Paula, or you know, whatever you need. I'm happy to follow up because I know there was a lot of information in a short period of time. So
Trish, can you just clarify one thing? You had mentioned teachers taking the summer off, but that wasn't legal, correct? Like the 30-day the 60 calendar days is still in effect. That's
correct. That's right.
Okay, so I think there might have been some.
Okay, so yeah, sorry. So yes, okay. The evaluations in the summer still do not need to be done within that summer. However, going back to that case, just remember that that court still said that that school had to have an because that child already qualified. The school had to have an IEP in place for that child to start the school year. So facts in that case make a difference, but correct, we still don't have to do evaluations over the summer.
Thanks for that clarification.
Yep. Mm-hmm.
You know, I know I'm not a special ed director anymore. Believe me, Trish was on my speed dial when I was. But I think we can never get enough information from our attorneys at sessions like this, because it really gives us time to pause and reflect on our practices and determine if our practices will hold up in due process. So the code for today's session, I'm going to put it in the chat, is TADP4. That stands for Trish Andrews Due Process 4. And it's just a reminder, I'm also going to put the survey that will be opened at the end of this afternoon sessions for people to fill out for Act 48 credit. Remember, you can get Act 48 credit for all of the afternoon yesterday and or all of this morning today, and our 2 post-conference sessions. So Trish, thank you as always. I know everyone across the Commonwealth appreciates your dedication and passion to the field of special ed and supporting districts. And we just want to thank you for your time today.
Yeah, I appreciate you asking me to give the seminar, and obviously anytime. Thank you.
Take care. The next session starts at 10:10. Everyone enjoy the rest of the day. Thanks so much.